Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss whether registration of a will is necessary or not. I am sure all of you with one voice will say registration is not compulsory for a will. The testamentary will need not be registered. Of course, it has got its own value because it comes into effect after the death of a person. Otherwise, the property or the person will become intestate. You all know this. When you are reading the sections of the Indian Succession Act, right from 211, 273, even 276 also Indian Succession Act, you all know about the testamentary will. And as per the Registration Act, please remember section 60, section 18E and also 63, they will come into effect. So normally there is no necessity for a registration of a will. But if it is not registered, why it has to be registered, you will know by seeing this case law. Please remember, this is by Jharkhand High Court. Sharwan Kumar versus Abhijit Kumar. So, in MA number 54 by 2012, decided on 18th August 2012. So, what is the effect of the non-registration of a will? This was in detail explained. Please remember. So, please remember, registration of a will is not necessary. Everybody notice. But once it is registered, the sanctity will be more. So, why we are sending the FIR to a magistrate? Suppose because he will put the date and time of the receipt. That will be sanctified. Court will give more value for the signature and noting the time and date of the magistrate. Likewise, if a will is registered, it is 100% useful for declaring the so-called probate before the district court. No doubt, you need not. There is no rule to say that, there is no hard and fast rule to say that it has to be registered. But the registration, please remember, it adds to the level of the authenticity or the probative value in favor of the names of the persons in whose name the will has been executed. And secondly, if anybody says, no, Your Honor, it's all false, his signature is fabricated, all these things, he has not come out, come at all before the registrar. So now, on whom the burden of proof lies? The person who claims that it is a forged will. So the bonus or the burden will shift from, please remember, will shift towards the objector to show that the registration was not was not correct or it is perfunctory. And please remember, therefore, the registration should be given a go by. It is his responsibility to prove the same if the registration is done. If the registration is not done, definitely you can claim all these things. So please remember. And in this particular case, what happened is there is a dispute between brothers regarding the will written by a father. What happened is, the allegation is the brother says that the father did not at all come to the registration office. The LTI or left thumb impression is forged. This is the thing. But since it was supposedly registered, now the evidence says that the LTA belongs to the father. And what you will say? Yes, authorized. It has got probative value. Therefore, if you get a case registered, if they get the registration done for the will, it is 100% acceptable. It has got authenticity. Right. So what is a will? First of all, let us know what is a will. Will is a declaration of the intention of a person. It is the declaration of the intention of a particular person with respect to his property or estate, which should be or which he desires to take effect after his death. So you all know, for this he has to write it. Of course, there is no pro forma. Then it has to be attested by 2 witnesses. If it is registered, it's okay. So please remember, section 211 to 223 of the Indian Succession Act, it deals with the registration or the how to draft the will. Please remember, section 276 is a petition for a probate. So after death, it has to be filed within 3 years, probate. And section 60 of the Registration Act, it's, please remember, the magistrate or the sub-registrar shall take, and there is no stamp value, and he has to affix registered, means it has got its own value. So please remember. Before that, section 3 says the registrar can administer the oath and recording the substance also, because it is oral will. So anyway, it will be in writing, and they will take oath, they will affix their signatures, and it is a proper or a deemed will. So please remember, no doubt. No, even I also say that a will need not be registered as per section 17 of the Registration Act 1908. But if it is registered, it has got its probative value. This you must know. If you know this much is sufficient. No doubt, everybody will say the so-called will need not be registered. But if it is registered, it has got its own authenticity, authority. That's more. So advise your parties to get the will registered. Thank you.